Good morning, everybody. Thank you, everyone, for attending this morning. We started this seminar about 10 years ago, our annual construction law year in review. We found it to be both a great service to our clients and a great way to market to our prospective clients. As a reminder, during the course of the year, I would encourage all of you to visit our construction law blog, which is www.lawblogconstruction.com. To stay up to date with current events impacting the construction law area. In terms of the materials that you have in front of you today, you've got a handout with all of the slides in it. There's a space in there to take notes. You're welcome to do so while we're giving the seminar today. There's also a jump drive which contains a PDF of the PowerPoint presentation. So if there's anyone else in your office or a colleague that you'd like to share this with, you're welcome to do so. There's also an evaluation form there. We would very much appreciate your feedback at the end of the seminar. If you could just take a few minutes to fill that out, it helps us guide the topics that we'll cover and logistics for our seminar for future years. So we've got a number of topics to cover this year. We'll jump right in. The first topic is going to be on mechanics lien law. I'd like to thank Jim Miller for assisting with the preparation of these slides. The first case we wanted to touch on is BN Excavating versus PBC Hollow. This was a case involving a subcontractor that performed excavation work and other site work in connection with a planned business park. A mechanics lien claim was filed by the subcontractor when the subcontractor was not paid for the work that they performed. Now, significantly, no improvement was ever constructed in connection with the business park through no fault of the subcontractor. While the case itself doesn't touch upon it, we did a little due diligence, and apparently this was pretty much right when the economy went in the tank and the financing on the project was pulled, so the project was never developed. Obviously, a situation that has occurred with some frequency since the economy went south. The trial court initially dismissed the mechanics lien claim, citing this Sampson-Miller case, holding that a lien claim cannot exist when an improvement, an actual building, is constructed. So the legal question presented in this case was, does the mechanics lien law preclude a claim for site work performed in connection with a planned improvement when the improvement is never constructed? Now, this case that I mentioned earlier that was decided long ago stood for the proposition that a lien can never attach to land absent an erected structure. The court observed, however, that nothing in the mechanics lien law requires that a structure actually exist or that construction of the improvement be completed. Rather, as the court explained, the lien law merely requires that excavation must be performed incidental to the planned construction of an improvement. So the court went on to look at the work that was actually performed in this case and held that when excavation work is performed that is completely independent and separate from a planned improvement, then you would not have lien rights. For example, if a developer bought vacant land and decided that they were going to excavate the property with the hope that the land would be more marketable if they were going to flip it after they did that excavation work, you would not have lien rights. However, the court said when the excavation is performed as an integral part of a construction plan, the activities fall squarely within the scope of the lien law, and therefore the contractor would be permitted to assert a lien with respect to that work. So the key distinction that the court focused on is whether there is a planned improvement or not. If there's a planned improvement and the excavation contractor does not get paid through no fault of its own, it would have lien rights. If there's no planned improvement, you would not have lien rights. So in terms of practical considerations, as we've indicated here, the decision provides site contractors with payment protection in instances where an owner abandons a project or runs into financing problems either before construction is completed or, in this instance, before construction was even commenced. So site work contractors, however, should make sure that their contract clearly indicates that the scope of work that they will be performing is part of a planned improvement if they want to protect those lien rights. And again, we thought this case was important, particularly in our unsettled economy when financing may get pulled on a project before it's completed. we thought that this case was particularly significant. The next case that we wanted to touch on was this Advanced Construction Services versus Cumberland Dining case. This involved a build-out of a mall right in Cranberry. This was Bar Louie that was constructed in Cranberry. The contractor was contending that the lessee, Bar Louie, failed to pay about $10,000. So what the contractor was trying to do was file a lien against the owner of the property. You can only assert a lien against the fee simple owner of the property if your work is performed for a landlord, if the fee simple owner, the ultimate owner of the property, if the improvement is for their immediate use and benefit. So in this instance, the contractor was asserting that they had those lien rights. Now, after the lien was filed, what you need to do as an attorney is get that lien served. So the attorney for the claimant attempted to do that. And in fact, ultimately, the sheriff signed an affidavit indicating that the lien claim had been served on all 4 defendants by delivering the lien claim to the general manager of the defendant at the tenant's address. Turns out the general manager was not the general manager of the owner, but rather the general manager of the bar of the tenant, and that's who accepted service of process. The owner itself did actually not receive notice of the lien claim until 2 years after it was filed, when the lien claimant filed a complaint to enforce the lien claim. The trial court dismissed the lien claim based on the owner's preliminary objection that the contractor failed to properly serve the lien claim on an owner. And that service needs to occur within 1 month after the lien is filed. So the question presented in this case is, was the contractor's service of the notice of a mechanics lien claim defective, and did it warrant dismissal of the lien claim? And the short answer to both of those questions is yes. And what the court did was focused on what it deemed to be an extraordinary remedy provided under the mechanics lien law and indicate that claimants must judiciously adhere to the requirements of the lien law. The court reiterated the well-established notion that strict compliance with the notice and service requirements of the lien law is necessary to perfect the lien claim. And although substantial compliance may excuse some missteps concerning the form of notice provided, it does not apply to a failure to strictly follow the service requirements mandated by the lien law. So the next slide touches on some of the specific sections that were important in the court's decision, including Section 1502 and then Rule 402 of the Rules of Civil Procedure. Ultimately, the court held that dismissal of the lien was proper because the contractor's service was not made at the owner's office or usual place of business or delivered to the owner's agent. So why is this case important to us? We thought it was important because it in many ways contradicts the holding of the Superior Court in Bricklayers of Western Pennsylvania versus Scott's Development. In that case, the court noted that the substantive provisions of the lien law must be liberally construed to affect the law's remedial purpose. However, as you can see from this advanced construction case, while the substantive provisions may be liberally construed, the procedural provisions of the lien law that relate, for example, to service of those lien claims are apparently still going to be strictly enforced. So you've really got to pay close attention to service of a lien claim, and you've got to pay close attention to those procedural elements of the lien law. So one of the takeaways for this purpose is, if you think you've got a lien claim that you're going to have to pursue, don't wait until the last minute to get that ball rolling. You've got to get that process started early enough so that you know the lien can both be timely filed, but then also properly served within that 1 month after filing. So that's really the takeaway from the Advanced Construction Services case. The next case we wanted to touch on, another mechanics lien case, the Hogg Construction Incorporated versus Yorktown Medical Center. In this case, and this is, I think, one of the last cases that you'll see published relating to the last lien law amendments. And the issue in this case was the contractor substantially completed its work back in 2006 and last billed any work in September of 2006. Now, in November 2006, they returned to the unit and did a little bit of work that they were contending related to base contract work. So once they go back and they do that work, obviously a lien was filed, so you know that they were not paid. They were contending they were not paid. They therefore file their lien on April of 2007. The complaint was then later filed. The trial court granted the motion for summary judgment and dismissed the lien claim on the premise that the claim was filed untimely because the contractor did not file within 4 months of completing the work. And the old period for filing a lien was 4 months. The new period is 6 months, and that changed in January of 2007. The trial court reasoned that the earlier version of the law applied because the work was performed before the amendments became effective. So the legal question presented is whether the date of completion of work or the date the lien claim is filed dictates which version of the lien law applies. The court looked at this issue and ultimately reasoned that the act amending the lien law provided that it applied to liens filed as provided by this act. Because the lien was filed in 2007, it was filed pursuant to the amended lien law, and the court deemed that the extended 6-month period would apply to the lien claim. So what's the takeaway from this case? Again, because this relates to a lien that was filed back in 2007, I think the significance of this is, as you're going to see later on, there are pending amendments out there right now to the lien law. So this case gives a little bit of insight as to how those amendments will be applied. And I think it's safe to assume, based on this case, that if your lien is asserted after these new amendments are passed, if in fact they are passed, you will be bound by the new amendments, regardless of when your work was performed. The other important takeaway, as I indicated earlier, the contractor was contending that the work that they performed in November of 2006 was the last work performed on the contract, even though that was billed to a general number and not this job-specific number. And it highlights, I think, when you're performing work on a project from a job cost perspective, I think a lot of times contractors don't necessarily pay a lot of attention to how you're coding those costs from a billing perspective. In this case, really highlighted the significance of doing a good job in that, because the contractor really created an issue for themselves based on their invoice, which it did not specifically reference this project. If it had, the issue of when the work was performed, I think, would have been moot. All right, one other case on the lien side, and most of the cases that we touch on are Pennsylvania cases. However, this case was decided in Maryland. We thought it was worthwhile because Pennsylvania has never specifically addressed this issue. And what's significant about it is the court was interpreting standard AIA language. A lot of times, historically, as lawyers, we struggle to understand how courts will interpret AIA language, because for years, the AIA had a default of arbitration, so you would have very few reported court cases dealing with AIA provisions. Since the 2007 amendments and to the AIA documents, we've seen more and more entities selecting litigation as a means of resolving AIA disputes. So on occasion, we will get court decisions. This is one of those decisions. In this case, you're talking about the 2007 AIA A201 general conditions, and specifically section 15.2.8, which provides that if a claim relates to or is the subject of a mechanics lien, the party asserting such claim may proceed in accordance with applicable law to proceed with the lien notice or filing deadlines. But then another provision in the dispute resolution provisions, and again, this is standard AIA language, states that claims, disputes, or other matters in controversy arising out of or relating to the contract shall be the subject to mediation as a condition precedent to binding dispute resolution. So you've got to mediate your dispute before you can proceed with whatever your dispute resolution mechanism was, either arbitration or proceeding to court. In this instance, the contractor asserted their lien claim and attempted to pursue the lien claim. The owner was filing a motion to dismiss or, at a minimum, to stay the lien claim pending mediation, arguing that mediation was a condition precedent to proceeding with the mechanics lien claim. And that was the issue that the court confronted, whether mechanics lien claims are subject to the AIA general conditions section requiring mediation before binding dispute resolution. And the court ultimately held that it is. We were a little bit surprised at this decision. The court rejected the subcontractor's argument that litigation does not constitute binding dispute resolution, as that term is used in section 15.3.1. Ultimately, however, the court did not dismiss the case. Rather, it just stayed the mechanics lien claim until that mediation was conducted. So what are the practical considerations emanating from this case? A couple that we have highlighted here. If you do not want a mechanics lien claim to be subject to a mediation provision, you need to specifically indicate that in your contract documents. Otherwise, the parties really are at the mercy of the court to determine whether the lien claim falls within or outside of the ADR requirement. And awaiting the decision of the court on this matter, obviously the concern is that's only going to further delay your attempts to seek payment. One other case that we wanted to touch on, we're actually still waiting on a decision on this, and this is the case that I mentioned earlier that had a much broader analysis of mechanics lien law and indicated that the lien law should be liberally construed to affect its remedial purpose. And ultimately, the court held that trade unions fell within the definition of subcontractor under the lien law and had the right to file a mechanics lien claim for unpaid contributions to union funds. As a result of this, a lot of union funds have been either pursuing or threatening lien claims on projects as a way to make sure that they get paid. The Supreme Court heard argument on this case on April 10th, 2013, and I actually checked last night at 11 p.m. and I can tell you no decision was rendered yesterday, so pretty confident that unless something's come out this morning, there's no decision in this case. I'm sure by this time next year we will have an update on you, an update for you regarding this case, and again, we'll be sure to touch on this on our law blog as soon as that decision is rendered. We're also tracking on our blog these proposed bills, and you may recall that last year we reviewed a draft bill that had been introduced that would have basically converted Pennsylvania's lien law to the approach that Ohio has taken, where Ohio requires a notice of commencement that the owner should file, is required to file, and then a notice of furnishing that any potential lien claimant is required to file. That bill died in committee, and ultimately this year 4 separate bills have been introduced that propose, in effect, what would constitute those same changes to the lien law. And I'm going to touch on these very quickly to try to keep us on schedule here this morning. The first proposed amendment is Senate Bill 145. And this bill has been lobbied for heavily by the banking industry. What this does is it relates to the super priority concept, and it would provide banks with a super priority to get in front of other lien claimants where at least 60% of the proceeds are intended to pay all or part of the costs of construction. And the cost of construction that you can see in this definition, and I wanted to make sure I used the pointer at some point just because I figured out how to do that. I don't really have a reason for doing it other than that. But in the second definition with respect to cost of construction, you can see that includes soft costs, which have historically been excluded. And banks were lobbying hard to get soft costs included in what would be entitled to a super priority. So again, this is being lobbied for pretty hard by the banking industry. The other thing it would do, it would relate to the ability of a subcontractor to lien a residential improvement, and as long as the owner of that property is using it or intending to use it as their personal residence, the subcontractor could not file a lien if the owner has paid the full contract price to the contractor. So what that is intending to do is put the risk on the relationship between the contractor and the subcontractor on residential construction projects, and it protects the homeowner. So if the homeowner pays the full contract price, a sub could not file a lien. This bill was introduced on January 15th, 2013. It passed the Senate in June and referred to the House Labor and Industry Committee in June, where it is currently pending consideration. And again, as I understand, this bill is being lobbied for pretty hard by the banking industry. House Bill 982 proposes almost the exact same amendments with a couple differences that we've highlighted on this slide relating to the specific definition of residential property. That's been an area of controversy with the lien law since it was amended. The initial amendments gave a very ambiguous definition of residential property, in essence saying it was a property used as a residence, which doesn't add a whole lot of insight into that definition. And the law has gone through a couple different amendments to more specifically define what residential property is. This bill was introduced in October, passed the House in November, and was referred to the Senate Labor and Industry Committee, where it is currently under consideration. Now, the next bill that we wanted to touch on, 473, is the bill that would in essence mirror Ohio's approach by creating a state construction notices directory and requiring the filing of a notice of commencement and then a notice of furnishing. The advantage of this, really, this provision has been lobbied for pretty extensively, not only by owners, but also by general contractors. The complaint by general contractors has been, when the lien law was amended in 2007, it permitted second-tier subcontractors to file liens. As a result of that, general contractors would oftentimes not know who those second-tier subcontractors were. So you could get a lien filed at the end of the job, and both the general and the owner were in the position of saying, I didn't even know that this second-tier subcontractor was working on my project. So how was I supposed to know whether or not they were being paid properly? So by requiring a notice of furnishing, it would alert everyone on the project as to who's providing labor or materials on the project, and therefore who's entitled to payment. So it provides knowledge to both the owner and the general contractor to ensure that all lien claimants are being properly paid. And you can see the way that this amendment would work is if a sub properly files a notice of furnishing, it's not required to serve the owner with formal notice of intent to file a lien as is currently required. And that's because, again, everyone at this point would know who has their lien rights. A couple other provisions in this House bill that we wanted to touch on. There is a provision in the bill that indicates that contractual provisions that prohibit the filing of a notice of furnishing are against public policy and therefore void. And we saw a similar provision with respect to the Contractor and Subcontractor Payment Act. After that statute was first enacted, some general contractors would attempt to require subcontractors to waive their rights under that statute. There's a case that came out that said you can't do that, that's against public policy. This statute would include such a provision right up front. And the amendments proposed by this bill do not apply to residential property, which was obviously a benefit to smaller contractors that are performing residential work. For other contractors, it would create an administrative burden in terms of the notice of furnishing. On the other hand, it's going to make your work on the project much more visible if you're a second-tier subcontractor, and from an owner and general contractor's perspective, it's going to provide you with the knowledge of knowing exactly who's performing work on your projects and therefore who has lien rights. This bill was passed by the House in September and referred to the Senate Labor and Industry Committee, where it's currently pending consideration. One other statute here, or proposed statute, a bill that's pending, Senate Bill 877, would amend Section 510 regarding the discharge of a lien by precluding lien claims against residential property for any amount owed on work that is shown not to meet building code standards of the municipality in which the work was completed. And this was an attempt by building code enforcement officers to indicate that if you're performing work that fails to comply with code, you're not going to have lien rights to ensure that you get paid. And then there was a provision that is proposed in House Bill 1697 that would expand the definition of lien law by explicitly including an engineer, an architect, engineer, or other licensed design professional as a person that may be considered a contractor or subcontractor under the lien law. The way the law currently reads, the only way that an architect or engineer has lien rights is if they are actually performing work on the job site. This draft amendment would expand that definition to include any architect or engineer that was performing work associated with the contract, regardless of whether they're performing work in the field.